Welcome to this AIM Quick Guide to select federal and Indiana employment laws. As with all of our quick guides, this guide is intended to offer AIM members an introduction to the topics, cases, and agencies herein. AIM Quick Guides should not be considered legal advice and should not be considered the single source of information regarding a particular topic. Should you need further assistance, please don't hesitate to reach out to us at aimindiana.org, and we'll be happy to link you with additional resources. To make this quick guide most effective, please find the complete text on the Quick Guides page of the AIM website, aimindiana.org. That document will provide more details, code sites, and acronyms, as this video is simply a primer, providing introductory information. Let's get started. OSHA, Occupational Safety and Health Act. Although the Williams-Steiger Occupational Safety and Health Act applies to private sector employers, Congress enacted a procedure to allow state governments to extend coverage to local government employers. The state standards must be as strict as or stricter than federal standards. Indiana adopted such a program in 1973, commonly referred to as IOSHA. Indiana Occupational Safety and Health Act. Every mayor and every town council is required to appoint a safety representative and notify the state on the name of the appointee. IOSHA law contains procedures for employee complaints and workplace inspections. Violations can result in safety orders or fines. There are also several record-keeping and reporting requirements for employers with 11 or more employees, including a requirement to log all occupational fatalities, illnesses, or injuries that required medical treatment beyond first aid. The log must be filed with the state and posted in the workplace annually. Employers may not discriminate against employees for filing a complaint or instituting a proceeding. Workers' compensation. Indiana's workers' compensation law establishes the system for providing compensation and benefits for employee injury, disability, or death by accident or by occupational disease arising out of and in the course of employment. All employers are required to purchase insurance from a carrier approved by the state or be self-insured under a plan approved by the state. The coverage must be for all employees with certain narrow exceptions. The chief exception for municipalities are police officers and firefighters who are covered by an alternative system in the police and fire pension laws. Municipalities may purchase insurance for the medical expenses of police and firefighters. A case concerning the interplay between the workers' compensation law and the police and fire disability system is discussed in Felix v. City of Mitchell. Employers may not retaliate against employees for filing a workers' compensation claim. Attorneys representing successful claimants may be entitled to attorney's fees under the statute. Federal highway regulations on drug testing. The regulations, promulgated by the U.S. Department of Transportation, require any city or town employing commercial driver's license holders in safety-sensitive positions to have a drug and alcohol testing program. A CDL is required for employees operating vehicles carrying hazardous materials, carrying more than 8 passengers for compensation, or with a weight of greater than 13 tons. The program must include a system for pre-employment, random, post-accident, reasonable suspicion, return to duty, and follow-up testing. There are also specific requirements for record keeping as well as supervisor and driver training. COBRA-Consolidated Omnibus Budget Reconciliation Act. COBRA is a federal law administered by the Department of Health and Human Services that requires local governments with 20 or more employees and which maintain an employer-provided group health plan to provide continuation coverage options to employees and beneficiaries in certain situations. These continuation requirements apply in circumstances called qualifying events when an employee or beneficiary would become ineligible for the group plan. Examples of qualifying events are employee death, termination or divorce, and a dependent child ceasing to be a dependent. Continuation benefits are extended coverage under the group plan at the employee's or beneficiary's expense for up to 18 to 36 months, depending on the type of qualifying event. When an employer is sued for COBRA violations, the winning party may be entitled to attorney's fees. Indiana laws similar to COBRA. There are state requirements similar to COBRA that apply to all local government employers and covers retirees, their spouses, and employees on leave without pay. The thrust of the requirements is to allow those covered by the statutes to continue on the municipal group health insurance plan until they reach the age to qualify for Medicare. It also provides how the premiums may be paid. HIPAA, Health Insurance Portability and Accountability Act. HIPAA is a federal law that has numerous provisions that regulate individual and group health plans and limits insurers from imposing certain conditions on policies. A significant portion of the law regulates health records and information, including such information retained by employers, to ensure that the privacy of individuals is protected. In addition, if a municipality maintains healthcare services, such as an ambulance service, then the HIPAA rules may apply to the use of the health information connected with that service. PPACA, Patient Protection and Affordable Care Act. PPACA is the wide-sweeping federal law requiring employers with 50 or more employees to offer employees health coverage or pay penalties. It also makes various changes to virtually every aspect of the healthcare system, such as coverage issues, deductibles and copays, dependents, and many other provisions affecting all employers. Some changes will affect the cost of group health plans for employers with fewer than 50 employees. State whistleblower law. State law prohibits retaliation against public employees who report violation of federal, state, or local law or the misuse of public resources. Employees who report violations in writing to superiors for violations of federal, state, or local laws or the misuse of public resources are shielded from disciplinary actions under certain conditions. The reporting employee must make reasonable attempts to ensure the information reported is correct. Indiana Military Family Leave Act. Indiana law requires employers of 50 or more employees to provide leave to family members of military service personnel called to active duty. An employee who has a spouse, parent, grandparent, or sibling of a person who is ordered to active duty may qualify to take up to 10 days of unpaid leave each year during the 30 days before or after active duty or during the period of active duty. Hurt on Duty Statute. A city shall pay for the care of a police officer or firefighter who suffers an injury while performing the person's duty or contracts an illness caused by performance of the person's duty. In a town with a board of metropolitan police commissioners, the town shall pay for the care of a full-time paid police officer who suffers an injury or contracts an illness during the performance of the officer's duty. A city or town that has paid for the care of a police officer or firefighter in a city under these statutes has a cause of action for reimbursement against a third party against whom the police officer or firefighter in a city has a cause of action for an injury sustained because of or an illness caused by the third party. USERRA, Uniformed Services Employment and Reemployment Rights Act. USERRA is a federal law passed in 1994 to continue and enhance employment protections for members of the military, including reservists. All employers, including local governments, are required to rehire individuals who left employment to serve in the military. The returning veteran is entitled to an equivalent position, including promotions that would have occurred if he or she had not served and remained in employment. The law also adds protection for disabled veterans by requiring reasonable accommodation and providing convalescent periods. Generally, the employment protection expires if the individual stays in the military beyond 5 years, but there are several exceptions. USERRA is administered by the U.S. Department of Labor, and the Office of Special Counsel receives cases from the Department of Labor that may be appropriate for litigation. No fees or court costs may be charged or taxed against any person who claims rights under USERRA. A court may award a prevailing person who retained private counsel for an action or proceeding reasonable attorney's fees, expert witness fees, and other litigation expenses. An employer cannot retaliate against an individual by taking adverse employment action against him or her because the individual has taken an action to enforce a protection afforded under USERRA, testified or otherwise made a statement in or in connection with a proceeding under USERRA, assisted or participated in a USERRA investigation, or exercised a right provided by USERRA. Nursing mothers' rights. These laws and regulations require public employers to provide paid break time for nursing mothers to express milk and make reasonable efforts to provide a room or location and also refrigeration. Employers with fewer than 50 employees are not subject to the FLSA break time requirement if compliance would impose an undue hardship, but the FLSA requirements do not preempt Indiana laws that provide greater protections to employees. This law only applies to municipalities that employ 25 or more employees. Volunteer firefighters responding to an emergency. This law prohibits municipal employers from disciplining an employee who is a volunteer firefighter who is absent from work by reason of responding to a fire or emergency call. The employee must provide written notice in advance that he or she is a volunteer firefighter. There are certain circumstances that do not require the employer to allow the employee to leave. Training and active duty of National Guard. Benefits of members. A municipal employer of a member of the National Guard, Reserve Component, and retired U.S. military must grant a leave of absence from municipal duties in addition to a vacation period without loss of time or pay while on training duties under the order of the Governor or the Reserve Component Authority for up to 15 days. Title VII of the Civil Rights Act of 1964. Municipal employers with 15 or more employees may not discriminate against employees based upon race, color, religion, sex, or national origin. Employers also may not retaliate against employees for engaging in protected activity. The Equal Employment Opportunity Commission administers the law, and employees who prevail in litigation are entitled to recover their attorney's fees. The Americans with Disabilities Act. Municipal employers with 15 or more employees may not discriminate against and must provide reasonable accommodations to qualified individuals with disabilities. The ADA also prohibits retaliation against an employee who has engaged in protected activity. The Equal Employment Opportunity Commission administers the law, and employees who prevail in litigation are entitled to recover their attorney's fees. The Equal Pay Act. The Equal Pay Act applies to municipal employers covered by the Fair Labor Standards Act and prohibits sex-based wage discrimination among employees who perform substantially equal work in the same establishment. The Equal Employment Opportunity Commission administers the law, and employees who prevail in litigation are entitled to recover their attorney's fees. The Age Discrimination in Employment Act. The Age Discrimination in Employment Act applies to all municipal employers and prohibits discrimination against an employee due to age. The ADEA also prohibits retaliation against an employee who has engaged in protected activity. The Equal Employment Opportunity Commission administers the law, and employees who prevail in litigation are entitled to recover their attorney's fees. The Family and Medical Leave Act. The Family and Medical Leave Act applies to all municipal employers and provides eligible employees up to 12 work weeks of unpaid leave a year and requires group health benefits to be maintained during the leave as if employees continued to work instead of taking leave. Employees are also entitled to return to their same or an equivalent job at the end of their FMLA leave. The FMLA also provides certain military family leave entitlements. Eligible employees may take FMLA leave for specified reasons related to certain military deployments of their family members. Additionally, they may take up to 26 weeks of FMLA leave in a single 12-month period to care for a covered service member with a serious injury or illness. The FMLA prohibits retaliation against employees for engaging in protected activity. It is administered by the Department of Labor, and employees who prevail in litigation are entitled to recover their attorney's fees. Section 1981. Section 1981 applies to all municipal employers and prohibits race discrimination in employment. Employees who prevail in litigation are entitled to recover their attorney's fees. Thank you for viewing this AIM Quick Guide to select federal and Indiana employment law. Again, please note that our quick guides are intended to offer AIM members an introduction to the topic. These quick guides should not be considered legal advice and should not be considered the single source of information regarding a particular topic. Further, this quick guide was recorded in November 2019. Information contained herein was accurate at that time. As mentioned earlier, please visit the Quick Guides page on the AIM website for more detailed information regarding this quick guide. Should you need further assistance, please don't hesitate to reach out to us at aimindiana.org. We will be happy to link you with additional resources. This AIM Quick Guide is sponsored by Taft. At Taft, we think forward. Taft's Municipal Practice Group offers clients a one-stop shop for their entire city or town's needs, including employment and labor relations. From prevention and defense of employment litigation, establishment of police and fire merit commissions, rules and disciplinary procedures, to counseling on day-to-day personnel issues, Taft has the experience and capability to achieve the best outcome for your city or town. Constructed a little differently, Taft has built its team with former corporation counsel and city attorneys. We not only understand the legal issue, but are also finely in tune with the challenges facing our local communities. Whether it be a budgetary challenge or political hurdle, from abatements to zoning, we understand because we've been there, and we're ready to put our team of experience to work for you. Taft is a modern, progressive firm and is the trusted advisor to many municipalities. Taft, playing to win and a proud partner of AIM. To learn more, visit taftlaw.com.